Morning. This is cause number 220742, Little Big Worm Ranch versus Doll. I'm set for the oral argument. Council ready to proceed? Ms. Lund.
May it please the court, my name is Hertha Lund, and I'm here on behalf of the Little Big Worm Ranch, LLC. With me is my associate, Peter Taylor, but I'll be arguing today. Also with me in the courtroom are my clients, Little Big Worm Ranch, some of the members who are part of that LLC. Little Big Worm is both the appellant and the appellee in this case. As the court is probably aware, Mr. Doll has a long history, several decades of litigating over these water rights, but there's 5 years of history of litigating with Little Big Worm, and those cases have been up. I think there's actually 5 total, I think, that have been up here. There's another one here already. So even though this battle is long and has been hard fought, the issue before the court today is actually simply a question of law. It's not a simple question of law, but it is simply a question of law. The water court adjudicated this water right in September 17th of 2019. And the chief judge called it in on a decree exceedance issue. The original preliminary decree was issued in 2009. On page 30 of the water court's order, he said the water rights in this case will appear in the final decree for Basin 40M as shown on the abstracts attached to this order. So in my briefing, I used the word abstracts a lot, but you could correlate that with the decree because it's been incorporated into the decree. This case is about our appeal, which Little Big Worm appealed on a dissatisfied water users action after the court combined 2 cases together. The first case was 1830, and that was brought because Mr. Doll locked the Headgate. Little Big Worm filed for injunctive relief and was awarded a temporary restraining order, and then at the hearing on preliminary injunction, the district court granted the relief of assigning a water commissioner, which is what Little Big Worm sought. Then Little Big Worm dismissed its injunctive relief cases or counts because it got its relief. The second case was brought because after there was an order by the district court that only the water commissioner could touch the Headgate, again, the Headgate was changed and the water commissioner said it was not him, and it benefited Dolls and not Little Big Worm. So Little Big Worm brought a second case to try to get its lawful property rights. This case is about 2 fundamental principles of Montana water law. Exclusive water court jurisdiction to adjudicate water rights, and the prior appropriation doctrine. We're asking this court to reverse the district court and remand with the instructions to follow the law and to stay within the district court's jurisdictional lane. The district court erred as a matter of law. Article 9 of the Montana Constitution recognizes and confirms the existing rights and that only the water court has the power and exclusive subject matter jurisdiction to be able to do those issues, and the water court is appointed by the legislature, and the legislature has the right to determine what the property interests are in Western water rights, and they relegated that to the water court. In Montana, water rights are real property interests. That's General Ag Corp versus Moore 534 P. 2nd 859. We also know, based on this court's prior precedents in Baker Ditch, El Dorado, Fellows, Deadmans, Kelly, Metler, and Meldenberger, all cases that I cited in my briefs, that the district courts lacks jurisdiction in a dissatisfied water user's case to do anything besides enforce the decrees. And in this case, the district court created a different period of use for Doll's stock water rights. They extended it from 10 months to 12 months. So that's a violation of the district or the water court's decree. Also in this case, the district court reallocated flow rates and ignored the water court's allocation of cubic feet per second. And the district court looked at the water court's rationale, and in that case, which you guys upheld, the court upheld, I shouldn't say you guys, I'm sorry. All right, so which this court upheld, the chief judge said that the way this land was once in common ownership of one party, and then was split later on. And when the chief judge was looking at how to apportion the water rights, he used the percentage of how much land they got as a way to determine the flow values. But he actually determined a flow rate. He did not say, and we see no water court orders telling the water commissioner or putting in an abstract a percentage. So what he looked at, it's almost like he looked at all the historic use and he came up with cubic feet per second, and then the district court said, no, I don't think that's what you meant, and then he reapportioned according to a percentage, which practically can't be done based on the parties' agreement. So the court is, I think you're probably pondering. Yes.
What do you mean based on the parties' agreement? It can't be done, you said, based upon the parties'
Yes, in the record and in my brief, you'll see that Water Commissioner Brian Robinson said it's near impossible. You can't, at this gate, it actually works backwards from a regular gate.
Right. I'm focusing just on your reference to the parties' agreement. What parties?
Oh, in testimony, my clients certainly don't think you can measure up there a percentage, 22 point whatever. You can't, that's just not possible. And Mr. Doll also said that in deposition, which I included in the record, and the water commissioner said that. So
they agree that you can't do what the water court,
what the district court
said. Okay.
Yeah, thank you, yeah. So I imagine the court's pondering of the question of how to administer water rights between co-equal rights, and whether this issue was proper for the district court to determine in a dissatisfied water user's action. I would argue it was not proper for the district court to approach that because, number one, Little Bighorn brought the dissatisfied water user's action. There was no issue in that brief or in that complaint about co-equal uses. And the district court also did not have a hearing that it's supposed to have pursuant to the dissatisfied water users statute. The district court in a hearing recalled us in, after you combine the two cases, to hear multiple outstanding motions in the two cases. He took us into chambers without a court reporter and decided to see if he could settle the case. And after that, we went back out into the courtroom and he gave us the order to give him findings or conclusions of law on how the water should be distributed. So this court was not properly before the district court on a dissatisfied water users issue on the ultimate issues that the district court decided, and it's not proper for him to do that because it's not his jurisdiction. It also would be a violation of the prior appropriation doctrine. So remember that this case was brought because Doll locked the Headgate, and then the Headgate was changed again in favor of Doll, not Little Bighorn. There was no issue regarding a call between these parties, or the call between two equal and priority rights. I would refer you to the handout that you have, which is the map. And on the map, if you can see, the Headgate where the parties own, and you also have the abstracts in case you needed to look at them. Both Doll and Little Bighorn have water rights that are co-equal in priority date with a September 25th, 1889 priority date to divert in section 20, and that water is to be diverted north into the reservoir that's in it's Ester Reservoir in section 17 and 16. And if one of the parties had filed a dissatisfied water users action about how the water commissioner was splitting co-equal rights that had the same point of diversion, it would have been appropriate for the district court to decide that issue. In this case, it was not brought before the court, and what's at issue is if you look down, look to the right, and go down 6 miles to the east, and you see the part that's in blue, that's Doll's place of use. And on their decreed abstract, it says that they have the right to divert at the same water right in sections 8, 9, and 10 for the place of use in 8, 9, and 10. There is not a decree or an abstract that says that Dolls can divert in 20 and use in 8, 9, and 10. So the district court basically reallocated the water rights according to point of diversion. So this is clearly a case in which the district court went beyond its jurisdiction, and in addition to deciding that dolls could climb up the stream 6 miles and stop Little Big Worm from diverting in Section 20, the district court expanded those stockwater rights, and then they also put a condition on low water use. And we know that the prior appropriation doctrine, it addresses when there's, that's what it's for, is if there's low water, it's a priority system, and who gets to go first. So we know that the district court, its sole authority would be to enforce the water right decree, and that includes the flow rates and the point of diversion. It had no right to try to make co-equal rights with different points of diversion share the pain during low flows, according to the prior appropriation doctrine.
Ms. Lund, let me stop you there for a minute, because the question that the district court seemed most focused on was what should happen in times of low flow, and seemed concerned that your position results in Dolls being the only party that doesn't get its full share during times of low flow, that because Little Big Worm's diversion comes first, your client would get all of its allocated share, and Doll would be the only one to suffer. How does your position address low flow times?
My position addresses low flow times by saying that the water court looked at historic use and gave us a priority date and points of diversion, and the district court does not abide by that. And in the middle...
Right, but because your point of diversion is first, that's what the district court seemed focused on. It becomes first in diversion, first in right.
And that's a cute way to say it, but the reality is that we know from the Kelly case that a senior appropriator can make a call on a junior. And if the junior, unless it's futile, the junior must heed the senior's call. Neither Little Big Worm or Doll is senior to the other. And Doll's argued that you couldn't subordinate either right, but that's exactly what the district court did. The district court reached upstream from Doll's right and subordinated Little Big Worm's right. So based on the priority doctrine, a senior can call a junior. A co-equal cannot call another co-equal. There is no law for that, and that's a violation of the decree.
And so how do you propose that it be handled by the water commissioner when there's not enough for everyone to get their full share?
Well, as the Medler case said, the doctrine of prior appropriation sanctions the right of an appropriator to use all of the waters of the stream. It's a prior appropriation doctrine. That is what it's about, is person in priority. And in this case, Little Big Worm can't take the whole stream. They can only take their 2.82 CFS.
So Little Big Worm gets its entire 2.82 CFS, and then Doll gets what's left.
That is correct according to the law, Your Honor.
So you're claiming that you have a water right just like everybody else does. There was this historical background that the water court worked through, but then they issued your client a water right that acts and works like a traditional water right. It's quantified in volume. If the water is in the stream, you get to take it out to fulfill your quantified volume. But when you read the water court's decision, it didn't treat it like a traditional water right. In fact, the water court reasoned that none of the parties, neither your client nor the Dolls, had actually proved their case in a traditional way, that their evidence and documents were not sufficient to establish a traditional water claim. And it said the only way that is equitable here is for me to allocate based upon a percentage, and I'm going to use this percentage to ensure, it said, as we mentioned in prior appeal, to ensure that each party receives its historical share. Mm-hmm. So how does each party receive its historical share if you are claiming that this is a completely traditional water right that has to operate in the traditional way?
I'm claiming that the court looked at all that and he issued abstracts. And he found that the historic use that if Dolls want to divert in section 20, they can divert into Ester Reservoir. And if that were the case and we weren't, then the district court there could be a action brought to require us to equally distribute it in the water that was sent from 20 into Ester Lake. But in this case, the water court clearly gave us a point of diversion downstream. And he said that those water rights that were downstream, 8, 9, and 10, if you look at those abstracts, the place of use is 8, 9, and 10. And the water is measured at the point of diversion. You cannot move that point of diversion upstream to section 20 like the district court did. The water court's decree is res judicata, and he said it was historic use for that point of diversion for those places of use to be at 8, 9, and 10. And essentially, the district court violated the water court's order by moving that point of diversion up. If Dolls wanted to do that without the district court doing it for them, they would have to file a change of use application under the change of use statute 853402. And before that change could be made, they would have to prove there was no injury to Little Big Worm. It is simply not allowable when you're enforcing a water right decree to change the point of diversion and allow them to go upstream and force that water to be stayed instream.
The water court said, in addition to this pro rata division flow rates, each party is entitled to a pro rata division of the water stored in Ester Reservoir. Now, it seems like why isn't that an indicator that it's ordering a pro rata sharing?
That's a good question, but it's very simple. The parties share a priority date, co-equal priority date, and point of diversion into Ester. So that's the reason it's pro rata. They do not share, my clients do not have a co-equal water rate to divert in section 8, 9, and 10. And so that part of the abstract is clear that that's where Dolls can divert and that's where they have to use, but they do not have a right to divert in section 20 to use in 8, 9, and 10 unless any water that's left over after Little Big Worm's 2.82 has to go downstream. So you have to think of it more like a deed. Water rights are like real property interests, and a deed sets the boundaries of how you use your land. An abstract does the same thing for a water right. It's the water court's job to determine the physical attributes of a water right, the property interests. That's a place of use, a type of use, a period of use, and the court has been clear over and over again that that's the water court's job. That becomes part of Little Big Worm's property right, is what's been decreed. And you upheld that decree. That decree was issued September 17, 2019. It's not like a 1918 decree. That decree is very recent, and the water court looked at the historic use, and despite his discussion about the parties lacking, he came up with a conclusion, and he allocated those water rights, and it's up to the district court to follow that allocation.
Well, we upheld a decree that used a method to ensure that each party receives its historical share of the Sebin and the Marshall rights. I mean, how does your argument ensure that everyone receives its historical share?
The court, when he was saying that, was telling you and everyone how he came to his conclusion. But what he issued to be attached to the decree is the abstract. And it's the abstract that has to be followed because that's the deed, that's the allocation of the interest in the property right. The rest of it's kind of like dicta or explanation of how he come to those conclusions. So I would,
You want to close down everything the water court said up until the point it issued the abstract, and you want to go just by that. But it seems like so much of the water court's decision was about historical use, which we affirmed.
Yes.
It was a unique decision that it made to divide these rights based upon historical use because nobody had proved their case in the water court at trial, and so it made this sort of special allocation. But it seems like the door gets closed on that consideration.
Well, if you do the math, The court took its allocation rate to determine the cubic feet per second. So he did take that into consideration. He said, this is what happened here. I did decide historic use, and this is the cubic feet per second and the points of diversion.
Thank you.
Thank you. So the issue before the court is how the district court ignored the water court's finding of historic use and adjudicated the water rights by allocated them with a new point of diversion and place of use, flow rates, and new time periods of use. I'm going to reserve the rest of my time, but before I do that, on the attorney's fees issue, I have read the 10 or more cases that Doll has cited to support their legal theory that they prevailed. However, not one of these cases stands for the proposition that a party could lose all of its counterclaims, have them dismissed with prejudice, not receive any of his legal remedies, and still be the prevailing party. So I'll reserve the rest of my time unless somebody has, another question, I would take that now. Thank you.
Thank you, Ms. Lund. Ms. Trinnell?
Chief Justice McGrath, may it please the court, Monica Trinnell on behalf of Willie Doll, and Willie and his wife Sherry are with me in the courtroom today. Before the court is the question of how to divide water when there's not enough water to fill co-equal senior priority rights. This map that is in front of you gives us a good starting point from which to work. So on this map, you'll see the point of diversion from section 20. That is known as the Ester Headgate, but not like typical headgates in Montana. It is actually in the creek itself. So the way that the water is operated, it either stays in the creek if the headgate is open, or if the headgate is fully closed, it will divert through the Ester conveyance ditch north into Ester Lake. That is how that point of diversion in section 20 works. So LBWR has its place of use, and its only way to use water from Big Worm Creek is through the Ester Lake. So it has to divert out of the Big Worm Creek into Ester, and then it irrigates out of Ester Lake. It has one point of diversion for its rights. In contrast to that, the Big Worm Creek water that was adjudicated, fully adjudicated by the water court and affirmed by this court in percentages, and as to that, I would direct the court to the water court order, footnote 9, which sets out the percentages of the allocated water from Big Worm Creek, and that was picked up exactly by this court in its order in LBWR v. Doll. Those percentages were picked up and affirmed by this court explicitly. Downstream from section 20 in the headgate that's in the creek itself is Doll's place of use further down here in the blue. Doll, adjudicated by the water court, has 2 points of diversion in section 8, 1 in section 9, and 1 in section 10. So he's got 4 points of diversion downstream, as well as the one in the creek in section 20. In addition to that, Doll may, but is not required, to use his water out of Ester Lake. So he could run his water through Ester Lake, run it north through Wild Horse Slough, and use it that way, use it directly out of Ester Lake, or keep it in flow in the creek. All of this is explicitly set out by the water court judge. That is the mechanics of how the system operates. In response to your questions, Justice Rice, in terms of what the record was, the water court actually looked very specifically at the historic operations of this ranch, the B.D. Phillips Ranch. He owned all of it, and he used the water. He used these reservoirs, which he built through the Reclamation Act, and he ran the water where it was needed, when it was needed. And so the fairest way to allocate the water was on a pro rata division of the water. Now,
He commingled them.
correct. So the question is, are those pro rata divisions 62% of the water is used by Doll downstream in the old home place of Phillips. 22% of the water is used by LBWR. Doll has 5 or 6 points of diversion, depending on whether it's the irrigation or the stock. LBWR has 1 point of diversion. Time of use. LBWR has a legal right to use its water for 5 months out of the year. In contrast, Doll has a legal right to use his water for 9 months out of the year. 9 months of the year, downstream, 62% of the water, 5 points of diversion. LBWR, 1 point of diversion, 22% of the water, 5 months of the year. That's what the court is looking at. The district court said that the water court's order allocating that water on a percentage basis meant that in August, when there is a trickle in the stream, you divide that 62%, 22%, and there is no record before this court on impossibility. None. That's not here. There was no evidence taken at the district court on that issue. It is not before this court. The water commissioner divides the water as instructed, as allocated by the water court, as instructed by the district court. The district court's order administering water rights said, during times of low flow, those same percentages apply.
And so, Ms. Trinnell, does the water commissioner make that determination at the Headgate?
Yes.
And
To clarify, at the Headgate in section 20.
yes.
And importantly on that point, Justice Baker, is the reality that if the court were to look at and entertain LBWR's argument that it should be looked at in sections 8, 9, and 10, as things stand right now, Doll bears entirely the burden of the carriage water. It's divided here in section 20, and that benefits LBWR.
So what about LBWR's argument that the district court expanded the time of use for stock water to 12 months? I think that's what she said, 12 months.
That argument makes no sense to me. How Doll uses his stock water right is it's left in the stream. That is the heart and parcel of Montana water law. Water stays in the stream unless you have a legal right to divert it. Doll's stock water is used by his cows drinking out of the stream. LBWR doesn't even have a legal right during those periods to the water. I do want to reserve time for my argument on attorney fees. And so to go back then to the question that's before the court really is the sentence at page 8 of the order administering water rights that Judge Jones entered that says during times of low flow. So the Stephen and Ester right is the older right. It's the September 1889 right. That's 12.5 CFS. So that's divided 62-22 as between these two parties, co-equal senior rights, of which Doll holds 62% of these co-equal rights. So the district court said, okay, we're going to share the trickle in August. And the way that this case came to this court now is that in July, late July, there wasn't any water coming down to Willie Doll's ranch. Every animal he owns was on that creek, and the headgate got shut. We went and got an emergency TRO to open the headgate so that that trickle would stay in the creek, because that's how people run their ranches in Montana, and that's how we keep our animals alive. So keeping that trickle in the creek is critical to downstream ranch operations. And the position being advocated by LBWR, think about it this way. Where on the abstract does it say upstream? Where does that get to be first? Why not start downstream? Why not give Doll all the water? If we're just going to randomly pick an upstream or downstream user, why not start downstream? Especially since he has the 62% share, 9 months of the year, 5 points of diversion, and has been there much, much longer.
Well, as a practical matter, we start upstream because the water's there. I mean, sometimes water isn't downstream,
Certainly, but if the majority,
upstream.
certainly, Justice Rice, but if the majority of it's being used downstream, I mean, who's to say what's practical?
Well, their position is, we have a water abstract that quantifies our water right, quantifies the volume. And we have, if there's water in the stream, and there's not a call made by a higher priority user, and technically that's not here, I know it's co-equal. The way water rights work is I get to take my quantified volume out of the stream at my point of diversion. That's how the law works. So, and I understand your argument, your fairness argument, but they want all the water. And it's not fair because we're downstream, but aside from fairness, what water principle do we apply that allows us to say the quantification of your volume right in the abstract can be ignored?
With all due respect, Justice Rice, this isn't just fairness. So on the abstracts themselves, you're ignoring Doll's co-equal senior water right to give him nothing. He has a co-equal senior water right. So the district court said when there's less than the flow that any party, there may not even be 2.81 CFS. LBWR might not get its entire flow. So how do you share the trickle between co-equal senior water rights?
So is the water principle that if you have two rights on a stream that have exactly equal priority,
Yes.
the upstream user can't use water in such a way that will hinder the downstream user that has the exact equal priority. I mean, is that a water principle? And where would we?
That is what the district court held, and it was
Where in water law we get that?
right. So there has been no case in Montana that I have found. You've got a lot of smart clerks that may be able to research this better than me, and I actually went nationally and I went outside of the legal framework, because how do you share the shortage? That's the question. How do you divide the shortage importantly, between co-equal senior water users, one of whom has 62% of the water for 9 months of the year.
The other of whom has the practical advantage of being upstream, and so the water reaches their point of diversion first.
Right.
Is it boiled down to just a practicality of who has access to the water first?
No, and I think, Justice Rice, I think that to push back on that a little bit, there are some factual questions that I think that the court would be getting into if it were to go very far down that path and say, well, practically, where is the water going? There was no evidence and no argument of futility, and no evidence and no argument of impossibility, none. The record before the court is purely on the question of how is the trickle split between co-equal senior water users on a pro rata basis when there isn't enough to satisfy two adjudicated water rights. So to be clear, if that's what the court wants evidence on, then we would have to have that adjudicated. But that's not what's before the court. That is not what LBWR has argued. There is no argument here on that issue. And I think that the water principle is very much prior appropriation. First in time, first in right. And so this is not an uncommon issue in Montana, where you have water that goes a long ways through meandering creeks, and some of it gets downstream. And it's essential that whatever is there in August gets to the place of use. And that's what happens here. That's a record before this court. We're asking this court to affirm the district court on that issue. I do want to spend some of my time talking about the attorney fee argument. I'm happy to answer any questions on this. But I think what's really clear and really important for the court to remember, this was fully adjudicated before the water court. It was affirmed by this court. And what the district court did is enter an order to the water commissioner, and the only language that was put in that was during times of low flow, that same percentage, which is not disputed and not at issue, is applied to whatever water is in the creek between co-equal senior water users. And to reach any other conclusion other than affirming the district court, this court would have to turn prior appropriation on its head and reverse 150 years of water law in Montana. So we're asking the court to affirm the district court on this issue. On the attorney fee issue, the way we got here today, in September of 2018, 5 years ago, LBWR filed a case in district court asking that the water in Big Worm Creek all be directed through Ester for its use first, for its exclusive use, pursuant to the 1975 Water Rights Agreement. That was the request for relief that LBWR was seeking in this 2018 case. It sought a preliminary injunction, and though those counts were dismissed, the count seeking relief under the 1975 agreement, which would have given LBWR the entirety of the Big Worm Creek water through Ester Lake, were counts 4 and 5 of that 2018 case. Then the water court held a trial at which LBWR argued vociferously that 1975 agreement controlled the way they used their water. Not historic use, but this contract. That was LBWR's position. And according to the contract, according to LBWR, they got the entirety of the Big Worm Creek water through Ester Lake. The water court rejected that argument and said historic use, pro rata percentages. This court affirmed that in August of 2020 in LBWR v. Doll. And then, a year later, LBWR filed another case in district court, 2021-34, in which it filed exactly the same argument, that the 1975 agreement, which this court negated and said had been merged into the deeds. LBWR filed another case saying, oh no, we think that 1975 water agreement still has life, and we think that it means we get all the water through Ester. That was what was presented to the district court, and that was what Willie Doll had to defend again. Not once, not twice, but 3 times he had to defend against LBWR's claim that the 1975 water right agreement gave it all of the water from this Big Worm Creek water rights through Ester Lake. And that was after this court had said no. So the district court entered orders on summary judgment, and you will find it at the district court order on attorney fees that we're appealing. It entered orders on summary judgment making an affirmative rejection of counts 4 and 5 of the 2018-30 complaint and count 3 of the 2021-34 complaint. Those 3 counts were negated by an affirmative summary judgment order, which is a final order, and that was the end of the 1975 water rights agreement. Finally, after 5 years, after a decision by this court, we got another final summary judgment order from the district court saying the 1975 water rights agreement is null and void. So the question that the district court decided on our attorney fee argument was that we were not the prevailing party. So what's before this court for review is, did we prevail on our claims in the 1975 water rights agreement? Were we the prevailing party? Was the district court, did it abuse its discretion in that regard? A secondary argument, and I want to revisit that prevailing party question, a second piece of that, though, is this is a contract, and the contract awards attorney fees to any party who prevails. So there's no question that there's a contractual right for attorney fees. That takes this case out of the line of cases where attorney fees are awarded on a statutory basis, or on a Rule 37 claim. This is a contractual case for attorney fees. So the narrow line of cases is really exemplified by the Kenyon Noble case, in which there was a counterclaim. Kenyon Noble was selling to a buyer who had a purchase agreement. When he finally closed up his shop, somebody took over his practice. The person who took over continued to buy on credit, didn't tell Kenyon Noble that, we're continuing to buy on credit here, ran up the bills. Kenyon Noble sued the first owner, and that owner, Mark, counterclaimed and said, we sent you a letter saying we're not responsible for these debts. And that was heavily litigated. That owner prevailed on 1 of 5 of his counterclaims. And there was the net money judgment it was a split judgment. But the analysis that the court applies in these contractual attorney fee cases is who is a prevailing party in the sense of what is at issue? What is the heart of the matter that's at issue? And who won that case? The heart of the issue before this court is how is water out of Big Worm Creek used? Who gets it? When? And during times of low flow. On that issue, Doll has completely prevailed on all of his arguments. It was Doll's argument to the water court that historic use and pro rata percentages should be the common sense application of how we use our water. Doll defended against that 1975 contract and said, no, there is no basis on which this contract requires water to go through Ester. This court agreed with the water court that that contract had merged into the deeds and is null and void. So on the issue of how is water out of Big Worm Creek used? When is it used? It has been Doll's position that has completely carried the day, completely. And so that is what's before the court. There's a contractual issue that LBWR sought to enforce. They put it before the court. Yes?
The district court discussed a number of other claims. If we were to agree with you and send it back, is there a way, would it be possible to allocate the fees between the contractual right and all the other stuff that went on in the history of the litigation to apportion?
Thank you, Justice Baker. It would be our position that in these 3 cases, in the 2018 case that was filed predicated on the 75 agreement, on the water court trial, which LBWR aggressively litigated the validity of the 75 agreement, and then on the 2021-34 case, that the nucleus of facts was so intertwined with that agreement that we should be entitled to our attorney fees for all 3 of those cases, both what happened in the trial court and what happened on appeal in all of those cases. That is our request of this court. And so we are asking for our attorney fees on the contractual agreement that LBWR came to the court and sought to enforce, submitted as an exhibit to both of the cases that it filed, and the plain language of that contract, which if you compare the language of paragraph 11 of the contract on attorney fees, the 75 agreement, to the contractual language that's at issue in Kenyon Noble, the contractual language in the 75 agreement as to attorney fees for both parties, setting aside the fact that the statute makes it reciprocal in any event, the contractual language alone is much stronger in this case, entitling Dolls to attorney fees for defending against LBWR's repetitive, consistent claim in the face of this court's decision that the 75 agreement had no validity. They filed another case asserting that it gave it all the water out of Big Worm Creek.
Counsel?
Go ahead.
So I'm just trying to reconcile the incongruity to say at the one time, on the one hand, that the contract has no validity except for the attorney fee provision. It seems to be what you're saying is, so we should recover under the attorney fee provision of a contract that we think has no validity.
Thank you, Justice Shea, for the question. The fact that the contract has no validity is something that we had to come to court and get a decision from you saying that. We're asking to have our attorney fees recovered because we had to do that. We had to come here, we had to say, no, this contract doesn't give you the right to divert water through Ester Lake out of Big Worm Creek. It's merged into the deeds. that was illegal.
Provision is still valid.
Well, I don't think that there's an incongruity there. I don't think that's inconsistent. So they assert that this contract gives it the right to divert water into Ester Lake. We come to this court and the court says, no, it doesn't. And the reason it doesn't is because it was merged into the deeds. So the fact that it's not valid because it was merged into the deeds doesn't negate the reality. They sought to enforce it. We defended it. We won. And so we're entitled to the benefits of the contract as they had put it before the court and made that argument. To find otherwise would totally negate any attorney fee claim. I mean, think of any contract where you have an attorney fee negotiated between parties and they say, well, this is a valid contract. I get to take your trailer from you because you're poor, or I get to, chase down your credit card fees or whatever. And there's attorney fee claim in there, and you win, and the contract is an adhesive contract or whatever. To use that analysis to say, well, you won, and the conclusion is that the contract isn't applicable. It's not valid. And so, but we can't do attorney fees, even though that was a part of the contract.
But there's a difference between saying that a provision of a contract is unenforceable or something because it was a contract of adhesion and whatever, whereas in here, we said and held that the contract merged into the deeds.
Right.
Prior to this litigation.
Right.
So I kind of get it with the prior litigation.
Right.
But with this litigation, it's already been determined that the contract was invalidated.
But we had to spend our time and money and our resources for a rancher in Phillips County, had to come to court 3 times to get that outcome. And so to say, well, we said it was invalid, you should follow that.
No,
I mean, how are we going to keep people in Phillips County from shooting each other if we don't enforce the rule of law?
No, I get that. I get that maybe there's an equitable argument or some sort of abrogation of the American rule, but just in terms of this current litigation, I'm trying to reconcile that when in the prior litigation, the contract was invalidated and we held that it merged into the deed.
Right.
So I'm separating the prior litigation and this litigation where that issue was resolved.
Right.
In terms of the validity of the contract.
So let me interject. So let's walk through this quickly. This case was initiated by
LBWR, yes. Chief Justice McGrath, yes.
and they ultimately did not prevail in this.
Correct. As to counts 4 and 5 on the 75 water rights agreement, because
I'm talking about this case.
the
The question, this was filed because the gate was closed.
correct, the 2021-34 case, correct. Yes. And if I may, Chief Justice McGrath, I think the linear function, and to follow up on Justice Shea's question, so the 2 underlying cases where there was an assertion of the validity of the 75 agreement and then the conclusive determination that it had merged into the deeds. So if the question is, well, prior to that, it was fair game because nobody really knew. So, okay, you get attorney fees for those 2 cases because you were litigating this provision. And then the case that was filed in 2021 was filed a year after this court said that it had merged into the deeds. So if the court's position is, well, you're not entitled to attorney fees on a contract, they're still trying to litigate even though we found it was invalid, then I would make the alternative argument, which we didn't brief because we didn't go down this road, but we are certainly entitled to attorney fees under the American rule in that situation. There is no set of circumstances where we should have had to come back a 3rd time after this court decided that they had merged into the deeds and relitigate that provision. So I don't know, Justice Shea, if that's where you're going in terms of parsing the linear function here, but.
Yeah, no, I mean, that basically was the gist of
Okay.
the quandary there.
I apologize.
No, that's fine, but that's where I was coming from.
Yep, so that's the linear nature of the sequence of events that has happened here. So,
Nell, excuse me. Are you done with the attorney fees?
sure.
Okay.
I didn't say I was done.
We need to fit this case into the prior appropriation doctrine. And can you articulate how a co-equal seniority fits into that doctrine?
Yes.
Because that's the issue.
Thank you, Justice McKinnon. And in truth, the only reason we fight about water is for the times when it's short, right? And Brian Robinson, the water commissioner, said, when there's water, water ain't a problem. When there's not water, water's a problem. And that's why we have water law. That's the entire reason and purpose for fighting over water, is to have it when you need it in August. And so the prior appropriation doctrine requires that as between co-equal senior water right owners, that the existing water gets shared to the extent that it can be split according to the pro rata percentages as set out by the water court. To reach any other decision in this case, it would require the water court to go back and re-adjudicate every case where it has entered an order as between co-equal senior water owners and add language that says during times of low flow. It has never been litigated before because it's so common sense that the whole reason we're here is you have those pro rata percentages for times of low flow. That's the only reason anybody ever fights about water. That's the only reason we're here. It has to apply to times of low flow. It's so common sense, it's never been brought up before. And as between co-equal senior water right owners, the court would be telling the water court, go back, and for every co-equal water right owner in Montana, you have to re-adjudicate it and enter an order that says during times of low flow, it's split on this pro rata basis.
Thank you.
Okay.
Thank you.
Counsel, Chief, can I ask one more question? So, and I don't mean to beat a dead horse here, hopefully not the doll's horse, but the essence of your argument is that the effect of the water court's order after trial in this case is that these parties in this co-equal priority situation are perpetually going to be part of a water sharing arrangement. Perpetually. And I'm wondering how we read that effect into abstracts that don't say it that way.
Thank you, Justice Shea. And the way to do that is to look at the table and look at the abstracts and say, they do say that. In fact, the water court order took its decision from those allocated flows. And they get 2.81 of a 12.5 CFS flow. That's 22%. The dolls get 7.77 CFS. That's 62%. So if the court would have the water court add percentages when there's a total allocated right onto the abstracts, that is a make-work exercise in all due respect, Justice Shea, because in fact they do say that. 2.81 is 22%. And the water commissioner said, how do I distribute this? And the district court said, 62% of what's there goes to Doll and 22% goes to LBWR. And if you want to do it downstream in points of diversion 8, 9, and 10, then LBWR can carry the burden of the carriage water. As it is in section 20, we carry the burden of the carriage water. And that's more than fair. Thank you, Justices. I appreciate your time and I appreciate your attention to this important matter in Montana water law. Thank you.
So one thing that Doll's counsel failed to tell you is that the district court on May 12th, 2020, ruled on the 1975 water rights use agreement claim. Little Big Worm has an arguable claim sufficient to withstand summary judgment and that are consistent with and therefore survive the water court's order. So the district court had ruled that it was still a viable claim. On the other issues. It was Doll's argument that the contract merged into the deeds and no longer was enforceable. And under the statute, or not under the standard of review, court reviews the district court for correctness if legal authority exists to grant fees. And under this case, there is no contract that survived Doll's arguments upon which you could grant fees. And the Dolls were not the prevailing party. If you look at the cases that they provided, the Supreme Court case, one of them was Buchanan, and it says, this view that a prevailing party is one who has been awarded some relief by the court can be distilled from our prior cases. So they have to get some relief. Otherwise, you would say that since a party didn't prevail on all their claims, I'm the winner and I get fees. You'd be doing fees all the time. There's always going to be those issues. Another case.
The argument that Doll is making is that they prevailed on the adjudication of the 1975 agreement. And in LBWR's dissatisfied water user complaint, you were still arguing for a declaration that Doll was bound by the 1975 agreement. But that came after our decision that said one meaning was derived from everything, from all three deeds, from the 1975 agreement and the agreement to sell and purchase, resulting in each party being entitled to its share historically used. So I think the position is that Doll was again forced to come in and defend against application of that 1975 agreement.
And that's because Judge Jones, the judge that stepped in, found that we still had an arguable claim that survived this summary judgment and the water court's order.
Under that agreement.
Yes, Your Honor.
But he ultimately,
Later, 2 years later, he decided differently. So another case, Kenyon Noble says that it has to be on paragraph 24, that in a situation involving a contractual award of attorney fees, when a defendant counterclaims and succeeds in having the plaintiff's claims totally denied but recovers only a portion of relief demanded in the counterclaims, the defendant is entitled to attorney's fees and costs. Dolls had no counterclaim on this issue. And then in Herringer, this court said, a district court is in the best position to understand the circumstances of the case and the parties' positions, and we will not reverse this determination of a prevailing party absent an abuse of discretion. There is no legal route for Dolls to get attorney's fees here. There is no abuse of discretion. And note that Dolls want to combine 3 cases to be able to get attorney's fees, and to combine 3 cases to say that they prevailed. And that has never been done before by this court.
I'm sorry to backtrack one more time, but
Sure.
I think you said that it was in May of 2020 that the district court said Little Big Worm Ranch had an arguable claim under the agreement. But our decision wasn't until August of 2020, and then you filed the dissatisfied water user complaint in 2021. So in the progression of things, we had already said the agreement was merged in with everything else, right?
Understood, but you also are aware that under the common law and statute, the district court has the ability to interpret contracts. And so since the district court had said that it was still alive, as a position of, extra careful for our clients, we wanted to keep every claim alive that we could. And, the district court said it was still alive, and the district court was ruling on the water court's issue, and even if, so we obviously thought in an abundance of caution that we needed to keep that claim alive. And you should note that if we did have to determine the fees, we spent very little time litigating that issue after the second case was filed in 1834, because the judge called us into chambers and issued this order and then issued another summary judgment, and we settled, and then we came up on appeal with the issues that we didn't settle. So Doll talked about the cases that they prevailed in. They didn't tell you about the case that they they failed in, which is the recent case where the jury awarded $2.5 million to Little Big Worm for actual fraud and actual malice that goes along with all these issues that have been coming up before you. And that case is currently on appeal, and you'll be hearing that. But that shows that Dolls have not prevailed on every claim. And you've been asked, what's the common sense approach? The common sense approach is to follow the abstracts. If the court does what Dolls are asking you can do, it's going to open up a partial call on upstream co-equal water rights. Right now,
What about, can you speak to Ms. Trinnell's comment? I mean, the abstracts do correlate
Yes.
with the percentages. So, I mean, how is the court not following the abstracts when it's, the CFS is based on, you know, in Doll's case, 62.17, and the CFS is reduced accordingly based on that percentage, and likewise the 22.46 for Little Big Worm Ranch?
I think the water court was very aware of that he was apportioning according to those percentages, and that's how he came up with the flow per second. So the district court doesn't have the authority to slice and dice those again and to ignore the flow rates. It's the flow rates that are a part of the property right. And he went to the, you know, he put that in the abstract in the decree. So I'm saying that, you know, we actually appealed that, obviously, but what we're asking now is to enforce the water court's decree where they did the pro rata division as provided in the abstracts, which provide flow per second for cubic feet per second. If the water court, he's never done it before, but if the water court wanted to say, you know, spread the water by percentages, it could have done that. I'm not sure it would be allowable under Montana law because we don't see those decrees, we don't see those orders. He took that percentage and assigned a cubic feet per second, and that's what has to be delivered.
But counsel, you've got two abstracts with the same priority date. How is enforcing it through percentages inconsistent with looking at both abstracts at the same time?
The court already applied those percentages in the flow rates. And he also came up with the points of diversion. He did not say that dolls have a point of diversion for their use in 8, 9, and 10 up at 20. He said their point of diversion for that right and that place of use is at 8, 9, and 10. And we measure at the point of diversion. And so what we're left with is that when you're co-equal, you can, if Doll wanted to divert into Ester, then this argument would be appropriate. If we were fighting over that, we're not. He wants to divert in downstream, and he wants this court, and he asked the district court, and the district court did it, to ignore adjudication and the water court abstracts, and I think a violation of the prior appropriation doctrine. I mean, why else would we have statutes that say if you're going to change your point of diversion or your place of use, you have to get a change application? It doesn't say if you're co-equal, you don't have to do that. In this case, they are downstream, and this court changed their point of diversion, and this is the relief that he granted. And that would turn everything on its head. Right now, when we have all these closed basins, think about it. The only way you can get new water in Montana is to go to your district court or forum shopping and try to see if they're going to modify co-equal priority dates so you can climb upstream and do something that's never been allowed before under the prior appropriation doctrine. That's what would turn the prior appropriation doctrine on its head. If you look at the decree in this case, it says flow rate and volume. The flow rate and volume is measured at the point of diversion unless otherwise noted in the abstract. It is not noted in the abstract that dolls can climb upstream and measure their places of use and their water rate with the point of diversion in 8, 9, and 10 up at section 20. That's 6 miles upstream. And we recognize that this court can look under the hood to determine how a decree should be interpreted. However, that's not the case here. It's not necessary on these facts. The decree is very plain. You have to read the plain language of it, and it says that Doll takes his water in sections 8, 9, and 10, or at section 20, but he can't take water in section 20 for use in 8, 9, and 10.
So is this, I mean, let's say, based on your argument, and we reverse the district court on that, then procedurally, are we just setting up another sequel for Dolls to come in and say, and seek a change in the point of diversion based on the percentages to 8, 9, and 10?
I don't think they can do it based on the percentages. They would do it based on, how they wanted to change, and they'd have to go through all the statutory reasons on why that was okay and why it was beneficial use and why it wouldn't harm Little Big Worm. And if we did it that way, Little Big Worm would have a right to make its case instead of just have the district court issue an order.
Okay.
Remember, we did not hear any evidence or legal argument on this issue.
No, I know, that's why I'm saying, aren't we just setting up another sequel there?
Well, I think if this court tells the district court that you have to abide by the abstracts, that's a pretty important statement in Montana water law. And, again, you're not deciding co-equals with the same priority point of diversion. You're deciding you've been asked to allow somebody with a point of diversion downstream to climb upstream.
Well, that leaves out consideration of the stock water right, the in-stream flow that the Dolls have.
Well, they do have a right to a stock water right, but the district court decreed that for 10 months out of the year, which means that during those 10 months, they can make a call on upstream junior. So in the district court's order, he expanded their use to 12 months. Now if there's water in the stream and it's in those 2 months that are outside of Little Big Worm's right to use water, arguably it's not allowed use because their water right, their historic use is 10 months. That's what the water court said. So if they have cows there and they're trying to use them for 12 months, they should have told the water court it was 12 months, not 10 months. They had their right to their time to adjudicate, and the water court adjudicated 10 months. But, it's about when a senior can climb upstream to make a call on a junior. And the district court changed that. I mean, the district court can expand places of use. Again, the decree says, and the Montana Supreme Court gave the right to the legislature, and the legislature said it's the water court that has sole jurisdiction to determine these attributes of a Western water right, which is place of use, time of use, period of use. All of those things are part of that property right. So we already talked about that the percentage of the allocated water was also the percentage of the cubic feet per second. So I think the chief judge was very well aware of historic use, and that's why he told us what he was going to do with percentages, and he put those percentages into the allocation of flow rate, which is a cubic feet per second. So he took that into accord when he issued the abstracts and the water rights decree. So there was an argument made that Dolls were without water. I want you to know that this is at a time, and the record shows that the water commissioner was handling the Headgate. And the only time the district court made decisions about telling somebody to quit locking it was against Willie Doll. There's never been allegations or any proof or any finding that Little Big Worm messed with that Headgate. And the court said nobody can touch it besides the water commissioner. So the question before the court is not how to share co-equal water rights when there's a trickle. That question was answered when Montana adopted the prior appropriation doctrine. The prior appropriation doctrine is a doctrine that deals when there's scarcity. And what it says is if you're first in time, first in right, you get your water right. It also says that if you're not first in, if you're a downstream senior, you can go upstream and call a junior. There is no provision in the prior appropriation doctrine that says a co-equal can call a co-equal. So if you're a co-equal and you're at the same point of diversion, then you have to do a pro rata split of your water rights. If you're a co-equal and your point of diversion is downstream, then you're the downstream user, and according to the parameters of the property right, you don't get your water right unless there's any water left after the upstream co-equal water right fills theirs. That is the prior appropriation doctrine, and you have many cases from this court that says that's how it operates, and there is no splitting in times of low flow as the district court adopted here. There is no provision under Montana's water law at this time, and it would be up to the legislature to create it to share the shortage. So Doll's argument concerning their stock water rights seems to want to elevate stock water rights above the irrigation rights. Again, there is no provision in the law that currently allows stock water, even if you can't water your cows, to make a call on an upstream irrigator unless you're senior to that use. So in closing, unless there are more questions, I actually have 2 minutes and 54 seconds left.
Go ahead and close.
Okay. So where the district court erred as a matter of law based on jurisdictional issues and statute and common law is that the district court ruled that he created a duty for Little Bigworm to leave water in stream and forego their diversion. That is making Little Bigworm's co-equal water right, subordinate to Doll's downstream right. That's not allowed either. That is, quite frankly, very unfair based on the common law and the abstracts, because it means they're not getting their decreed water right, their property right. And then the district court said during times of low flow, you say nothing in these abstracts or this decree that makes one way to allocate water in low flow and one way to allocate water in adequate flow. The water court's job was to allocate these water rates based on historic use, and their abstract and their allocation is what is supposed to be applied when there is low flow and when there's high flow at all times. So the district court violated both the principles of its jurisdiction and the prior appropriation doctrine when it rewrote the allocation of water rights as between Dolls and Little Bigworm. This court has held many times that on a dissatisfied water user's action, the water court's duty is to enforce the abstracts. The district court's order elevated Doll's rights into senior rights instead of being co-equal. It's Little Bigworm's rights who are curtailed under the district court's order. If the district court order is allowed to stand, water rights, as we know in Montana, will be modified to disregard the prior appropriation doctrine, statutes, case law, according to water rights. And I really think that this would be the next place to be able to find a new water right, is to seek where there's co-equals and then go forum shop to go to the district court to see if they'll disregard the water court's abstracts. So thank you very much, and we ask you to remand back to the district court on the issue of whether or not, on the dissatisfied water user's action for failure to, for lack of subject matter jurisdiction, for failure to follow the statute and the common law of the prior appropriation doctrine, and to deny Doll's request for attorney's fees since they were not a prevailing party and they did not have a contractual right to be able to get those fees, and there was no abuse of discretion by the district court. Thank you very much.
Thank you, Ms. Lund. Thank you to both counsel. That concludes the argument in this matter. We will take it under advisement and issue an opinion in due course.